Welcome to the deep dive. Today, we're taking on a really provocative idea, one that sort of turns conventional history on its head.
It really does.
The idea is this. The destiny of a nation, its rise and fall, isn't really determined by the size of its army or how much gold is in its treasury or even by some charismatic leader.
No, not at all.
Hmm.
It's determined by something far less glamorous, but infinitely more important.
One, often overlooked, foundational element: the strength, the clarity, and the independence of its courts.
That's a massive claim, I know, but it is entirely supported by the powerful comparative analysis we have in our sources today. When we talk about, national resilience and longevity, we tend to focus on the big outcomes, GDP, military power, that sort of thing.
Right, the flashy stuff.
Exactly. But the source material insists we look deeper at the internal architecture of justice itself. We're analyzing the very foundation of how power is constrained, how rights are standardized, and ultimately how citizens are compelled to actually trust the state.
And what makes this dive so fascinating is that we are connecting three seemingly totally separate historical moments to uncover what looks like a universal truth about political stability. We're starting in the 11th century Seljuk administration in the medieval Islamic world. Then we're going to jump across half a millennium and a whole continent to 19th century Napoleonic France. And then we're landing in 20th century Pakistan, specifically in 1954.
And our mission here is to give you, the learner, a kind of shortcut to being really well informed about statecraft. We're going to show how these legal foundations either build a state up or fundamentally undermine it from the inside out.
So the focus is laser sharp on judicial architecture as the key structural element.
Yep. We're comparing two astonishingly successful, long-lasting models, the Seljuk and the Napoleonic, against one really critical failure point in Pakistan's early constitutional history.
And our sources, especially the insights from constitutional lawyers Ahir Ahmad Mir, they show that while monuments and empires themselves, they inevitably crumble into dust, the systems of justice, the laws, the codes, the procedural discipline, they have this enduring quality that can shape political systems for centuries after the founders are long gone.
Precisely. The core conclusion we are working towards, based on these three cases, is, well, it's pretty undeniable. Empires' fall laws survive. We are tracing the lineage of legal ideas that dictate political success far more effectively and for far longer than any dynastic line or military campaign ever could.
Okay, let's unpack this. We're starting in the 11th century, and we're plunging right into the turbulent heart of the Islamic world. It was experiencing a major identity crisis and an institutional meltdown just before the Seljuks arrived on the scene.
And this wasn't just a political squabble.
No, this was systemic failure.
That context of crisis is absolutely essential to understand what came next. By the mid-11th century, the political structure, which was largely inherited from the Abbasid Caliphate, was deeply fragmented and just rapidly deteriorating.
So what was at the root of that? What was causing this crisis?
It was really rooted in the dilution of central authority.
Okay, so specifically, what triggered that dilution? We all know the Abbasid caliphs were, in theory, the supreme religious and political leaders, but what was the reality on the ground?
Well, the sources are pretty clear that they retained only symbolic authority in Baghdad. Their real power base had just evaporated.
Why?
Primarily because the military had become semi-independent. It was often composed of groups like the Mamluks, who held allegiance only to their local commander, some local strongman, not to the caliph.
So this military and administrative weakness allowed power to just decentralize and splinter away from the center.
Rapidly, yeah.
So if the central spine was gone, the power devolved to regional actors. How did that actually manifest for, say, an ordinary person?
Oh, for the common person, it was chaos, complete chaos. You had regional governors operating out in the provinces who began acting completely independently. They were essentially micro-rulers.
The little kings in their own domains.
Exactly. Collecting taxes, managing their own little armies, and critically, they were responsible for appointing the local court system. This move from a centralized administration to these decentralized fiefdoms, it just allowed corruption to flourish.
It seems obvious that when justice is administered locally by the very people who stand to gain from injustice, the rule of law just completely collapses.
It collapses completely, and the widespread corruption in provincial courts was the core issue. Justice depended entirely on local power, not on any established uniform law.
Can you give us an example of how that worked?
The sources are very specific here. Regional governors often used a system of tax farming. It was known as ikoi.
Okay.
And they essentially bought the right to collect taxes in their region. So they needed the local judge, the qazi, to validate their often exorbitant claims against the populace.
So if the Qazi was appointed by and beholden to the governor,
Then the legal system was merely an extension of the local governor's economic self-interest. It was a tool for extraction, not justice.
and a population that sees the law as a tool of exploitation, not protection, is going to lose all trust in the state.
Exactly. The lack of judicial independence eroded public trust entirely. I mean, when citizens feel that the foundational promise of the state that they will be treated fairly under the law is broken, their loyalty just shifts.
Right, it has to.
And on top of that, the political instability created a vacuum where all these various sectarian movements and dissenting groups could thrive, which just further weakened the social and religious unity you need for stability.
So the Seljuks, this new unifying Turkish force, they basically stepped into a ready-made administrative and constitutional disaster.
The total mess.
And the architect who came to stabilize this immense region was, fascinatingly, not a military figure, but the Grand Vizier Nizam-ul-Mulk Tusi. He died in 1092.
A true bureaucratic genius.
He seems to be the one who recognized that, sure, force could win you a battle, but only law could win you an empire.
Nizam-ul-Mulk is such a towering figure. He was the Grand Vizier for the Seljuk Empire, serving under 2 successive sultans, and he just understood that legitimacy comes from structured governance, not just from military might. He saw that the key to permanence was establishing institutions that could survive a weak ruler.
And his vision is famously captured in his legendary book, the Nizam-ul-Mulk, or the Siyasat-nama, the Book of Governance. What was the core philosophy he put in that book that became what we're calling the Seljuk principle?
His core philosophy was simple and almost brutal in its honesty. An empire survives only when justice is central.
That's pretty direct.
Very. And he wasn't talking about abstract philosophy. He was talking about practical, day-to-day state maintenance. He argued that the moment a ruler separates himself from the rigorous, impartial pursuit of justice, or even worse, stiff manipulating the courts, that ruler is actively undermining his own legitimacy and basically triggering the countdown to collapse.
So the Siyasat-nama became more than just a philosophical treatise. It was an operational manual. It was a how-to guide for ensuring justice was central.
That's a great way to put it.
So what were the specific detailed principles he mandated to revolutionize their governance?
He established this incredibly comprehensive administrative framework, and it was all focused on controlling the arbitrary exercise of power. And you see principles that sound astonishingly modern for the 11th century.
Like what?
Well, firstly, he mandated strict, formalized judicial independence. He detailed anti-corruption measures that weren't just, recommendations, but structural mandates.
And that structural mandate had to address the root problem you mentioned, governors running the local courts.
Absolutely. The foundational principle was the rigorous appointment of qualified qazis, the judges. He demanded a complete separation of political authority from judicial authority.
So what does that mean in practice?
It meant the regional emir or governor could not simultaneously control the judges who were supposed to be adjudicating land disputes, tax disagreements, and holding that same governor's agents accountable. A clear conflict of interest.
So separation of power is the structural safeguard. But he went even further, right? Focusing on procedural fairness. How did he make sure the common person felt protected by this new system?
He put a huge emphasis on procedural fairness. The mechanisms of justice had to be transparent. And for the common person, the most important innovation was the formalization of the Diwan al-Mazalim.
The Court of Grievances.
The Court of Grievances, exactly. This was a high court, often presided over by the Sultan himself or a trusted representative, that citizens could appeal to directly if they felt they had been wronged by a governor, the police, a tax collector, anyone.
Wow. That created a centralized check on regional power, giving an ordinary citizen a real voice against the most powerful provincial elites.
That's it, exactly. It placed strict limits on royal power by making even the sultan subject to procedural review, and it established clear mechanisms for the accountability of governors. Nizam-ul-Mulk built a system designed not just to tolerate justice, but to actively enforce it, even against the interests of his powerful local allies.
This sounds like a massive undertaking. I mean, how did he actually enforce the system across such a vast territory? What was the most important practical reform that centralized the whole thing?
The key reform, the linchpin of the whole system, was the centralization of quasi appointments.
Okay.
Under the old fragmented system, judges were local appointments, which ensured their loyalty was local. Nizam-ul-Mulk broke this cycle completely.
So, if the Seljuks wanted a nationwide rule of law, they had to make the judiciary a central, standardized state function, even if it meant political backlash from governors who were losing their judicial patronage.
Precisely. Qazis were now appointed through central oversight, typically through the Grand Vizier's central office, the Diwan, and this meant the judge's loyalty was directed towards the central administration and the codified law itself, rather than to the local political strongman who previously held their job security in his hand.
That transfer of loyalty is everything, isn't it?
It's the whole game.
But central appointment alone doesn't guarantee integrity. I mean, how did they keep these powerful, centrally appointed Qazis honest?
This is where Nizam-ul-Mulk's administrative genius really shines. First, they implemented strict qualification standards for judges, ensuring they were learned in Islamic jurisprudence, fiqh, and possessed strong ethics.
But what was the real stick? The mechanism for accountability?
It was the regular audits of court decisions and the use of an official called the Mustafi.
The Mustafi. Tell us about that role.
The Mustafi was essentially the chief auditor or controller of the empire. And they weren't just checking tax receipts. They were performing institutional checks. They would proactively review judicial proceedings and financial records to ensure that governors weren't manipulating the courts for financial gain.
So it was a mechanism of built-in accountability, a self-correcting legal structure.
Yes, a highly refined separation of auditing and spending.
Audits of judicial decisions, that is institutionalized self-correction. And I imagine this also protected the Qazis themselves, giving them the shield they needed against local pressure.
Yes. A judge who knew his impartial ruling had the backing of a powerful central auditing body, and that any deviation could lead to his swift removal was far more likely to resist the local governor. This system ensured protection from political pressure while simultaneously allowing for the removal of corrupt judges. It was a tightrope walk of centralized power being used to guarantee local fairness.
The genius of it is so clear. This system creates a uniform legal environment, which is the absolute prerequisite for large-scale political stability. So what was the immediate and the long-term impact on the vast Seljuk Empire?
The impact was transformative. It led to a nationwide rule of law, which means predictable, consistent justice across territories stretching from Central Asia all the way to Anatolia.
And that predictability allows for administrative discipline.
And crucially, stable taxation. People are far more willing to pay taxes and comply with laws if they know the courts will protect them from arbitrary theft or extortion by local officials.
It also must have reduced rebellion because the legal system provided a legitimate avenue for people to address their grievances rather than having to resort to violence to solve disputes or protest corruption.
That's exactly right.
Yeah.
Nizam-ul-Mulk essentially saved the Islamic world from internal collapse by institutionalizing justice and stabilizing the administration. This stability allowed the Seljuks to focus on external challenges. The core lesson is codified in what we're calling the Seljuk principle. If justice goes, the empire goes.
Wow.
And this legal infrastructure stabilized the region for centuries. It laid the foundations that were adopted by successor empires, including the Ottomans and the Mughals.
That is profound. We're talking about institutions that were so successful they influenced state building across continents and across half a millennium.
Incredible, isn't it?
It really is. Now, let's maintain this theme of judicial architecture determining destiny and shift our focus. We're jumping centuries later and across continents, landing in France in the early 19th century.
And here we move from a Grand Vizier building stability through bureaucratic standardization to another great, but profoundly different architect, Napoleon Bonaparte. And we're looking at his most enduring non-military legacy, the Civil Code of 1804.
The Code Civil. It's such a fascinating parallel because Napoleon was obviously obsessed with empire, but the code is what really defined the modern state. Before we look at what he created, let's quickly look at the chaotic legal mess he inherited from the French Revolution.
Oh, the legal landscape of pre-revolutionary France was an administrative nightmare. It was a patchwork of hundreds of different legal systems. Hundreds. In the south of France, they largely followed what was called pays de droit écrit, written Roman-influenced law.
Yeah.
But in the north, they used pays de coutume, local customary laws, often inherited from old Germanic tribal traditions.
So if you traveled, 50 miles, the definition of a contract or a marriage or property ownership could change completely.
Absolutely. One source claims there were over 400 regional variations of customary law. This legal uncertainty was a huge hindrance to commerce. It made property transfers opaque, and it ensured that true equality before the law was impossible because the law itself was inherently fragmented.
And layered on top of all of this were the feudal privileges, right?
Yes, that was the other huge problem. The Code Civil's primary revolutionary act was abolishing these privileges. Things like the droit de chasse, the exclusive right of the nobility to hunt on any land, regardless of who actually owned it,
Unbelievable.
or the local tolls and tariffs imposed by regional lords rather than the state, and these complex inheritance laws like Majora, which forced the majority of a family's property to be inherited by the eldest male, preventing the free sale or division of land.
So the law itself was fundamentally anti-capitalist. It was designed to protect inherited status over merit or contract.
Yes, and Napoleon recognized that if he wanted a stable, unified, and economically dynamic state, he needed clear, uniform, and rational laws. And that is exactly what the Code Civil delivered.
So detail for us what Napoleon achieved. What were the defining characteristics that made this system so powerful and long-lasting?
The sources highlight three massive achievements. First, it standardized rights and contracts. This brought unprecedented clarity to property law, commercial law, family law. It ensured uniformity and predictability across the entire nation, regardless of region or previous customs.
So if you signed a contract in Bordeaux, you knew exactly what it meant in Paris, no more guesswork.
Exactly. Second, by abolishing all those feudal privileges, the code established the sanctity of private property and the equality of all citizens before the law. Your rights and your duties were now dictated by the code, not by your birth status.
And a third.
And third, provided the foundation for standardized courts, ensuring that one clear, written legal standard was applied uniformly by all judges.
This standardization and clarity provided the exact antidote to the fragmentation and uncertainty that plagued pre-revolutionary France, much as Nizam-ul-Mulk's reforms cured the fragmented abbasid state.
It provided the operating manual for a modern civil administration. It was accessible, written in clear French rather than archaic Latin, and it was comprehensive. It was designed to be applied by any moderately trained judge anywhere in the empire.
So here's the central paradox, and this is the key takeaway for our deep dive. Napoleon's empire fell, and it fell swiftly in 1815 after Waterloo. France went back to being a monarchy.
Right.
But his legal system, the Code Civil, survived. It survived across successive French regimes and was exported across Europe to places like Belgium, parts of Germany, Italy, and it even influenced states far beyond, like Louisiana in the U.S.
It's the ultimate proof of our theme.
This dramatically reinforces that central idea. Empires fall, laws survive.
It is the ultimate testament to institutional excellence, isn't it? Napoleon's political achievements were ephemeral. They were tied to his personality and his military force. But his structural legal system achieved a form of near immortality because it fulfilled a fundamental human need for order, predictability, and fairness, regardless of who sat on the throne. It was simply too functional to discard.
Okay, so let's unpack the structural parallels here. I mean, an 11th century Muslim vizier and a 19th century French emperor, their success hinged on what seemed to be identical structural legal decisions. What are the direct lines we can draw between the Seljuks and Napoleon?
The similarities in their institutional design are just profound when you put them side by side.
Yeah.
Both were solving a core problem of fragmentation and corruption through centralization and the standardization of justice.
Right. So on the Seljuk side, the problem was corrupt local courts, and that was solved by standardized judicial appointments enforced through central oversight and qualifications.
Which is mirrored perfectly in the Napoleonic system by the creation of standardized civil courts that were all applying a single written text. Both of them realized that consistency in the application of the law requires consistency in the appointing and disciplining of the institution itself.
Then you have the Seljuks instituting rigorous anti-corruption court audits via the Mustafi, proactively checking decisions for bias.
And that is structurally equivalent to the Napoleonic emphasis on rule-based judicial discipline. Judges were codified into a specific bureaucratic framework. They weren't political figures who could just invent law anymore. They were expert administrators who applied the code, subject to standards and appellate review, which dramatically reduced arbitrary behavior.
And the most vital link, I think, is Nizam-ul-Mulk's emphasis on the independence of judges, protecting them from local governors.
Which is matched by Napoleon ensuring the judges were separated from immediate political pressure. Their decisions were based on the code, not on the prevailing political winds. They became career bureaucrats of the law, not temporary political appointees.
And fundamentally, the entire purpose of all this was to benefit the state by benefiting the citizen. The Seljuks ensured access to justice for common people, protecting them from powerful governors.
While Napoleon guaranteed equality before the law, protecting the citizen from the remnants of aristocratic privilege. Both systems were about shifting legal power away from local powerful elites and toward the general population, which dramatically increased their trust and their buy-in to the state structure.
So Nizam-ul-Mulk's structured administration led directly to Napoleon's modern civil administration.
It did.
This comparison just shows that political longevity isn't a matter of culture or era, but it's a matter of structural engineering.
Absolutely. The common denominator is crystal clear. Both of these architects prioritized structural clarity, standardization, and judicial separation from immediate political pressure. They saw the judiciary not as some temporary tool of the ruler, but as the essential protected mechanism for legitimizing authority and ensuring the state's permanence.
Okay, that brings us to our third case study, which is a critical warning sign. We've looked at two amazing success stories that built their states on strong judicial architecture. Now we look at a constitutional crisis in early 20th century Pakistan that illustrates the devastating consequence of that judicial heart weakening under pressure.
This transition is so crucial because it's a parallel crisis. It's the same challenge of institution building after a period of fragmentation, in this case following the British departure, but one with the exact opposite outcome. It provides a kind of negative control for our historical experiment.
So the setting is Pakistan's early constitutional history, specifically the pivotal events of 1954. What exactly was the nature of this constitutional crisis?
Well, following independence in 1947, Pakistan was struggling to draft its permanent constitution. The interim governance was guided by the Modified Government of India Act of 1935.
The holdover from colonial rule.
Exactly. The Constituent Assembly was the supreme elected body, and it was tasked with drafting the permanent law of the land. The crisis was triggered when the Governor-General, a man named Ghulam Muhammad, an unelected bureaucrat, a former civil servant, unilaterally dissolved the Constituent Assembly.
So the unelected executive authority essentially dismissed the nation's highest democratic legislative body. That puts the entire constitutional process into question.
It was an act of pure executive overreach, a direct challenge to the supremacy of the people's representatives. The sources frame this as the moment the constitutional balance, which was already fragile, was truly shattered.
And the challenge to this dissolution was brought by the Speaker of that assembly, a man named Maulvi Tamizuddin Khan. What was the specific legal basis for his argument against the Governor-General?
Tamizuddin Khan's argument was an appeal to parliamentary sovereignty. His lawyers argued that the executive did not have the prerogative powers to dismiss the Legislative Assembly, which represented the highest elected political will of the nation. His core philosophy really echoed Nizam-ul-Mulk. No executive authority may override the people's representatives. The law and the people who make it must be supreme.
This was the moment the nascent state had to decide its identity, wasn't it? Rule by law and parliament, or rule by arbitrary executive will inherited from colonial structures.
Yes.
The fate of Pakistan's constitutional destiny rested entirely on the federal court.
It was the ultimate test. But to truly understand the ruling, we need to understand the legal loophole the Governor-General exploited. Since Pakistan was operating under the Government of India Act of 1935, that act required that all amendments to its structure must receive the assent of the Governor-General to become law.
A rubber stamp, basically.
A colonial rubber stamp, yes. And Tamizuddin Khan's case relied on an amendment that had not received this official assent.
Okay, so the Governor-General claimed that since the dissolution was related to the structure of the assembly, and the assembly had been operating without proper formal assent for its own enabling laws, he was just correcting a technical legal defect.
Exactly. The Governor-General claimed the dissolution was valid because the Constituent Assembly had not correctly formalized its own procedures. It lacked the proper technical assent from the executive, which, again, was a relic of colonial rule.
So, what was the verdict? What did the Federal Court of Pakistan, led by Chief Justice Muhammad Munir, decide? Did they uphold the supremacy of the elected parliament or the technical prerogative powers of the executive?
The federal court, by a majority decision, sided with the executive. They ruled that, quote, the Governor-General retains prerogative powers, specifically because the laws establishing the Assembly's power lacked the formal assent required under the inherited 1935 Act.
So they upheld the technical deficiency over the democratic principle of parliamentary sovereignty?
They did.
That decision fundamentally inverted the constitutional balance. The court essentially said, form is more important than substance, and technical colonial procedures outweigh the will of the elected representatives.
It was a catastrophic precedent. The source material outlines this as a profound judicial error because it wasn't just a legal ruling, it was a political statement that validated executive dominance over the legislature. And even worse, this ruling would later be implicitly reinforced by what's called the doctrine of necessity.
What's that?
The idea that sometimes illegal actions by the executive, like a military coup, must be validated by the courts in order to prevent national chaos.
A very dangerous idea. Let's detail those corrosive consequences because they are the clearest demonstration of what happens when that judicial heart weakens.
The list is devastating. This judgment immediately weakened Parliament. I mean, if the legislature can be dissolved in the whim of the executive, even on a technicality, it loses its core power and legitimacy. It renders its actions temporary and conditional.
Right, and it must have empowered unelected authority.
Massively. It essentially gave undue leverage to the bureaucracy, the military, and other non-representative forces who could now cite prerogative powers or necessity to justify extra-constitutional actions.
So this decision didn't just cause a political imbalance at the time, it laid the foundation for decades of future institutional instability.
It created a deep systemic flaw. It nurtured constitutional imbalance by permanently tilting the scales toward the executive branch. And historically, the sources state very clearly that this judicial yielding enabled future coups. It provided the legal rationale that allowed subsequent military leaders, like Ayub Khan, to seize power and then pressure the courts to retroactively validate their actions.
And to bring it back to our central theme, it severely damaged judicial independence. By siding with the executive in this critical moment of high pressure, the federal court signaled that it was not the ultimate impartial protector of the Constitution, but a secondary institution that could be coerced by the powerful.
And this is the critical failure when you view it against our historical successes. The ruling confirmed that the courts yielded to the executive when pressure was applied. This is the direct opposite of what Nizam-ul-Mulk structurally mandated in the 11th century. Courts must be protected against the actions of governors and rulers.
It's the opposite of the structural clarity Napoleon imposed.
Exactly.
So we have a devastating direct contrast here, where the Seljuk and French systems strengthen the state by structurally guaranteeing and upholding judicial independence and the supremacy of written law.
Pakistan's earliest judicial decision weakened the state by validating arbitrary executive prerogative and yielding to that authority on a technicality. The source material argues that if the Seljuk principle judicial independence and the supremacy of law over the ruler's will had been followed in 1954, Pakistan's constitutional history would have been significantly different. It could have potentially led to stable democratic evolution rather than recurring crises of military rule.
This comparison is so essential for you, our listener. It moves legal history out of the textbook and into the realm of existential state survival. It shows that one court decision can literally change the entire trajectory of a nation for generations.
Absolutely. And I think we need to review the full comparative chart side by side, because seeing the three outcomes mapped out is the most powerful way to internalize this lesson. We have three civilizations, three judicial turning points.
Okay, let's run the comparison starting with our successful foundational architects. First, the Seljuk justice system under Nizam-ul-Mulk.
The outcome was clear. It strengthened the rule of law by creating independent quasis whose loyalty was centralized. This led to long-term stability supported by enhanced citizen trust. The key design feature was protecting the courts from local political governors.
Okay. Next, Napoleon's Civil Code of 1804.
The outcome was equally successful in its intent. It strengthened national legal unity by establishing independent civil courts, applying a single rational text. The result was long-term codified clarity, which empowered the common people by establishing equality before the law and protecting the courts from the chaos of feudalism and monarchy.
And finally, the warning sign, the Tamizudin case of 1954.
And the outcome here was structurally damaging. It weakened institutional balance, resulting in executive dominance. The court structure failed the central test. The courts yielded to executive pressure on a technicality. The consequence was long-term constitutional instability and an erosion of public trust and legality, which set a tragic precedent.
The data set is complete. Two built legal empires that survived their founders, one that undermined its constitutional foundation with a single ruling. This brings us to the core argument, the ratio decidendi, the central truth shared by the author about the relationship between law and the state.
And here's where it gets really interesting, connecting these three seemingly disparate eras. The core truth distilled from all three cases is this powerful and often repeated metaphor. A court system becomes the heart of the state. If the heart weakens, the body collapses.
The heart. It's not the muscles, the army, or the bank account, the treasury. It is the steady, reliable, rhythmic institution that pumps the lifeblood of order, legitimacy, and predictability throughout the entire body politic.
And if that pumping is inconsistent, if it's corrupt or subject to external force or the fear of the powerful, the whole system will eventually suffer systemic failure. The Seljuks and Napoleon prioritized protecting that heart from political pathogens by installing structural barriers. The 1954 court ruling allowed the executive pathogen to take hold, prioritizing the state's technical survival over its constitutional soul.
Let's summarize the final impact statement just to bring home the magnitude of these judicial turning points.
Okay, consider the sweep of history. The Seljuk judicial reforms didn't just fix a local administrative problem, they fundamentally stabilized the Islamic world and provided a durable governmental template that lasted for hundreds of years.
Napoleon's civil code didn't just reform French law, it literally remade Europe. It influenced legal systems globally, providing the legal clarity necessary for modern commerce and equality, and it's lasted longer than any empire or dynasty that followed him.
And Pakistan's early judicial error in the Tamizuddin case didn't just lose a single legal battle. It fundamentally shaped decades of political imbalance, favoring executive dominance and contributing directly to recurring constitutional crises that continue to haunt the state structure to this day.
The central truth seems undeniable across continents and epochs.
It is. The core moral lesson, which is articulated so powerfully in the sources, is that a great nation is not built by temporary measures like armies or wealth. It is built by courts that are strong, fair, independent, and structurally beyond the immediate reach or whim of the rulers, whether those rulers are 11th century viziers or 20th century governor generals.
That structural integrity is the true measure of a state's destiny. We have explored the crucial role of judicial architecture through the eyes of Nizam-ul-Mulk, Napoleon, and the early constitutional hurdles faced by Pakistan. It's a remarkable comparison that teaches us that legality, predictability, and independence are really the engines of longevity.
Indeed. What legal history teaches us, I think, is that what feels like a pragmatic, short-term political compromise by a court often sets a constitutional precedent that the nation cannot shake off for generations. The judiciary is always building the future, one decision at a time, and every single decision either reinforces or compromises the structural foundations of the state.
So, before we sign off, we want you to apply this thinking immediately. Think about the standing institutions in your own country, or even within your own field of work, that are the true hearts of stability. Are they protected from immediate political pressure? Is their independence structurally guaranteed by central auditing oversight, like Nizam-ul-Mulk required?
Or are they vulnerable to being dissolved or overwritten at the whim of the powerful executive?
It's a critical question.
And let's bring it back to the source itself for a moment. We mentioned that this analysis comes from Mr. Zahir Ahmad Mir, a constitutional and corporate lawyer and the author of over 55 books. This isn't just dry academic history. This is applied constitutional insight, written by someone who has dealt with the practical reality of compromised legal systems.
That real-world application is the ultimate validation of the thesis, isn't it?
It makes us ask a final, provocative question based on the monumental, enduring success of the Seljuks and Napoleon. What level of commitment, what depth of architectural genius, and what degree of personal political risk does it take for a system to achieve the enduring success of a code like Napoleon's or the institutional stability of Nizam-ul-Mulk's reforms? What fundamental political sacrifices must you make today to ensure your legal heart keeps beating independent and strong for centuries to come?
A question that truly defines the rise and fall of nations. Thank you for joining us on this deep dive. We hope this has given you a powerful new lens through which you view history, power, and the law.
Until next time, keep exploring the foundations.